Hello everyone. Welcome back to the Mentorship Project. I am Utkarsh Pandit, presently serving as a law clerk cum research associate at the Honorable Supreme Court of India. Today, in this video, we are going to delve into the complete guide on how to prepare for this examination, as this examination offers an invaluable experience to work closely with the judiciary in India. But before moving forward with the examination structure, I would like to first delve into the roles and responsibilities which a law clerk is expected to work upon. So, one of the basic roles which a law clerk is expected is researching. So, law clerk is expected to prepare the drafts of judgments or to prepare some research materials like articles, etc., for the honorable judges. Further, another important role of a law clerk is to take notes. During the hearings, a law clerk is expected to record the arguments of the counsels and to assist the judges in preparing the judgments. Now, third important role which a law clerk is expected is summarizing. So, law clerk is expected to prepare briefs on a daily basis and to acquaint the honorable judges of the Supreme Court by preparing the synopsis for the cases. Now, what are the benefits of clerking at the Supreme Court? One of the major benefits is the great exposure to a large volume of cases that are very high profile. Another important benefit is to seek mentorship from some of the top legal minds in the country. And the networking opportunities are enormous at the Honorable Supreme Court of India. So, it is really a good opportunity. Now, coming to the examination structure. So, the examination pattern for the law clerk examination is divided into three parts. The first is the MCQ part, the second is the subjective paper, and the third is the interview stage. So, let's deep dive into the MCQ part of the paper. The MCQ paper has 100 questions, and each question carries 1 mark each. And in case of a wrong answer, a negative marking of 0.25 is there. The syllabus for the MCQ paper is English, then there is a law portion, and another portion is regarding the recent developments in law. So, in the English paper this year, there were three reading comprehensions asked. So, these reading comprehensions were part of the excerpts taken from the judgment of the Honorable Supreme Court of India. One another reading comprehension was a part of the article published in the Yale Law Journal, and the third one was an excerpt taken from the Constitutional Assembly debate. Now, dissecting the law portion, so the questions were asked from the following subjects, including constitutional law. There were around 18 questions, and around 10 to 11 questions were asked, each from Civil Procedure Code, Indian Penal Code, Criminal Procedure Code, and the Indian Evidence Act and Contract Act. So there was more weightage to the constitutional law as compared with other laws. Now, coming to the third part, that is the latest developments in law. So there were around 15 questions from this particular section, and the Supreme Court had already released a list of around 43 judgments which a candidate had to prepare for this particular section. And preparing for those 43 judgments not only helped you in acing the MCQ section, but also helped you in preparing for the subjective portion as well. So, now coming to the subjective portion, the subjective portion was divided into three parts. So there were a total of three questions only in the subjective part. However, the paper was for 3.5 hours and it included the 30 minutes reading time also. So the first question was brief preparation. in this particular question, the candidates were provided with an SLP, that is the special leave petition, or a writ petition, a civil appeal, or a criminal appeal. And the candidate had to prepare a brief synopsis of the particular case. The synopsis should not be more than 750 words, and it should not be ideally not longer than 2 pages. So, as far as this year's question paper is concerned, there was a dispute regarding the dismissal of the petitioner from service without following the principles of natural justice. So, apart from the SLP, the candidates were also provided with the impugned judgment, that is the judgment of the Honorable High Court, along with some judgments of the subordinate courts. So in this way, the candidate had to go through all those documents, that is the SLP, the impugned judgment, the order of the subordinate court, and other documents annexed. So totally, it was around 30 to 32 pages, which a candidate had to read before preparing the synopsis or the brief. Now here one should be careful that the SLP that is filed by the petitioner already has a brief synopsis of the case, but the candidate should not entirely rely upon that particular synopsis, because that presents the petitioner sides of the case and thus is not able to give you an unbiased view of the complete case. So it is important to first read through all the documents and then prepare the synopsis or the brief. Now moving forward with the second question, that is the research memo. For the research memo, the candidates were provided with a dispute, and the question paper also provided with the relevant statutes and the judgments, that is the precedents laid down by the Supreme Court, High Courts, and foreign courts also. So in this particular question, a candidate had to prepare a research memo, which means a candidate has to give his or her legal opinion based on the factual dispute and the law in place. So in this year's question, the dispute was regarding discrimination to women at workplace, and the candidates were provided with the provisions of the Constitution of India, the judgment of the some of the judgments of the Honorable Supreme Court, and a lot of judgments from various high courts and some foreign jurisdiction judgments also. So one needed to analyze the facts and then apply the law, that is the constitutional provisions, as well as the precedents laid by the Honorable Supreme Court, High Courts, and some other foreign jurisdictions to the particular facts of the case, and then come to the conclusion. So while writing the research memo, it is important that the candidates apply a certain structure to their answers. Like they must mention the facts in brief, then the issue, then the question of law involved, analyze that particular question of law involved, and apply them to the facts, and then come to the conclusion. So then comes the analytical question, and it was around 75 marks. And the analytical question requires the candidates to write upon a particular question of law or a particular judgment. So there were around 5 questions for this particular section, and one had to write on only one. So that was an optional question to write any one out of the 5. So in this year's question paper, the 5 questions were regarding the R.C. Cooper versus Union of India judgment and the interpretation of Article 21. So, what was the interpretation from R.C. Cooper to the Menka Gandhi case? This was the first question. Then the second question was regarding the constitutional validity of Jallikattu. The third question was regarding the Subhash Desai versus Principal Secretary case. Um and the fourth question was the SR doctrinal shift made by SR Bomai case, exercising the power under Article 356. And finally, the last question was the remedies in constitutional law for interfaith couples. So, if these questions are concerned, these were not abstract, and most of these questions were taken from the part of the list of that 43 judgments provided by the Supreme Court before the examination. One needs to ensure that one is well acquainted with those judgments that have been provided by the Honorable Supreme Court Recruitment Cell before attempting the examination. Then the last stage is the interview stage. However, one needs to make sure that as far as the rules are concerned, a candidate needs to secure at least 40% marks in the MCQ paper. Only then his or her subjective paper will be checked. And the candidate needs to get 50% marks in the subjective paper to qualify for the interview round. Now, coming to the interview round, so the interview round is not much structured, or one cannot guide on what the interviewer may ask you. So, one can generally prepare well for the CV because that is what you have submitted. So, one needs to be sure of his or her educational background, the internships or the work profile one has done before, the publications or the moot court competitions one has participated in, so one can be much confident for the interview. Another tip for the interview round is to give some mock interviews to your peers, mentors, or professors. So this way, they can guide you on your mistakes or the way you speak, and you can ensure that you are well prepared for the interview. So in case you are a judiciary aspirant, this examination could be a cakewalk for you because you have already prepared intensively on these core subjects, that is the constitutional law, CPC, CRPC, IPC, Evidence Act, Contract Act, etc. However, still, if you have not prepared much, I think going through the basics of these subjects would be helpful. And one can also prepare by reading the previous year question papers. The previous year question papers are available on the web, and one can uh, study through those previous year question papers and create a question bank of his or her. So this is another way if you don't have much time left. Now, for the subjective paper, it is important that while writing, you follow a structure for your answers so that the examination does not have to look deeply into what your answer wants to say or what is the conclusion. So it is important that you mention the subheadings while writing the answer so that your answer is clearly structured. At last, I would like to say that even if you prepare for this examination well, getting selected is a matter of luck or chance. It is important that we do our part well and leave rest to the God. Thank you.